Constitutionally Speaking is a program by the Office of the Public Defender. It empowers you with knowledge to protect yourself and your loved ones. Stay informed, stay empowered, be in the know. Catch Constitutionally Speaking every Tuesday at 8:05 a.m. on the Richie Morning Show, because knowledge is power.
Dance, discover, and stay informed.
Thank you for tuning in here in Jamaica on the Rock, as we like to say, on Best 100 FM. Thank you for tuning in, those who are checking us out courtesy of Reggae North Radio out of Toronto, Canada, silkradiok.com out of London, our friends on, of course, linkentertainmentglobal.com out of Las Vegas, Nevada. We've got listeners checking us out in Florida, our newest edition, courtesy of Roadblock Radio on 102.7 on the FM band HD3, and naturally in the tri-state area, also on Roadblock Radio 101.1 on the FM band HD3. We welcome you now on the Richie B Morning Show to our feature that happens every Tuesday morning at 8:05 or thereabouts. It's Constitutionally Speaking. And you know, my guest is going to be introduced momentarily, but let me tell you, it has been observed that at the opening of the Hillary session of the Home Circuit Court last week, there were great concerns, I'm told, expressed over the large number of sexual offense cases that were on the court's list, many of which we understand were committed by young people. There was an argument that rapists are walking free from the courts, and that the sentences for rapists are too light. The concerns reignited the debate on sexual offense, and in particular, sexual offenses by teenagers upon teenagers. And so it is timely and quite topical that this morning we are in fact looking at that matter on Constitutionally Speaking. It is the Sexual Offences Act that will be looked at this morning, and we're very pleased to be joined once again by Mr. Herbert McKenzie, the Deputy Public Defender, as my guest. Good morning, Mr. McKenzie. How are you today?
Good morning, Mr. Fine. Thank you. And here also is the Public Defender herself.
Really? Good morning.
Yes, right here.
Good morning, madam.
Good morning, and surprise.
Very surprised. I'm almost speechless. But we're very, very happy and pleased to welcome you this morning. Only our second program in the series, and here you are joining us already. Thank you so very much, Mrs. Cameron Reed.
Thank you for the welcome.
And she'll be here for many, many more, sir.
I am very happy to hear that. Wonderful news indeed. Now, let me regain my composure and continue with the program. This is a very topical issue now, Mr. McKenzie, wouldn't you say?
It is indeed, yes. It is. Everybody's talking about it. In fact, I think even the children's advocate did mention something that the differential in age should be taken into serious consideration when it comes to charging for offences of sexual offences between teenagers. Mm-hmm. But so it is. The debate rages on.
It does, and we want you to both help me to dissect this matter this morning. And I think I want to start by pretty much asking you to assist us in understanding how rape is defined under the Sexual Offences Act.
All right. Rape is defined in law as the offense whereby a man has sexual intercourse with a woman without her consent, and knowing that woman does not consent, or just recklessly not caring whether or not she consents. Now, if the consent is obtained by fear, force, or fraud, the law doesn't regard the consent. So in short, sexual intercourse upon a woman by a man without a consent. That very definition tells you that the offense is gender specific. That is, it's specific to the male. Only the male can commit it. And that is so because the rape can only occur if there is vaginal penetration by a penis. And biologically, we know who has penises or who has vaginas. So it's a gender specific offense. Only a man can rape a woman under Jamaican law. And you might be interested to know what the penalty for that is.
Yes.
the penalty for rape, if the accused is convicted, is life imprisonment with a minimum of 15 years. Statutory minimum, 15 years.
Would that be if an adult is convicted?
If an adult is convicted, because we come to the scenario where the accused person is not an adult within the meaning of the law. So in Jamaica, like I said before, only a man can rape a woman. Now, you raise the issue about adult, and that is a good segue into the next offense where the accused is not an adult. In the law, it is referred to as sexual offense with a person under the age of 16. 16 under the law is considered the age, is considered a child. Anybody 16 and under in the law is considered a child when it comes to sexual offenses. Now, there's the offense which I just mentioned, having sexual intercourse with a person under 16 years old. Now, the actual act, the law is a curious term they call it actus reus. The conduct that constitutes the offense is the same as in rape. Vaginal penetration by penis. It attracts the description because the accused person is the defendant or the victim or the person allegedly raped or have the sexual offense committed against him or her is under the age of 16. That means that person could not give consent.
Yes.
So, like I said, the act is the same, but by virtue of the age, it is termed differently. Now, the penalty for that is really the same as rape, the minimum being not less than 15 years. If, however, the person accused of the offense stands in authority or guardianship position like parents over the child, then the judge may use that under the law. The judge is allowed to refer to a statutory minimum of 10 years. And in most cases, that person is removed from the guardianship or authority position over the victim.
All right. Wow, we're learning quite a bit. As a matter of fact, we're joined, as you'd have heard, by the public defender herself, Carolyn Reed Cameron. And I want to bring you in, if you will, Madam Public Defender, on my next question, really, which has generated quite a bit of discussion since I posted last night that we'd be having it discussed this morning. Under the law, Mrs. Reed Cameron, can a woman rape a man?
It doesn't appear so, and that's the short answer. Based on the statutory definition of rape that has been given in Section 3 of the Sexual Offences Act, there has to be penetration of the female sexual organ by the male sexual organ, and the reverse does not apply.
So we have never had a scenario like that on our books at all?
Not that I'm aware of.
And if we were to have it, there would be other provisions under the Sexual Offences Act that would cover it. Things like indecent assault, previous sexual assault, a whole slew of other offences which could cover the conduct of that female whom the allegations are leveled against.
Sexual touching.
Sexual abusing if the child involved. But rape, no, it can't be. Not in Jamaican law. In fact, the one we're talking about earlier on involving teenagers, remember I said that the conduct, the act is the same?
Yes.
You have jurisdictions like America call it statutory rape. Because, in fact, outside taking the normal meaning of the word rape, it is rape. It's just that the age of the victim is below 16. So you can't give consent, and consent is one of the ingredients to rape or the lack of it. It doesn't attract the nomenclature of rape, simply statutory rape. But we in Jamaica, we call it sexual intercourse with a person under the age of 16. Prior to the Sexual Offences Act, it used to be called carnal abuse. But the conduct of the defendant remains the same. Legal jargon, that's all they're
And the mental state as well. Meaning it is done without the woman's consent, or you're reckless as to whether or not she consents.
Now, I want to mention something about this one, teenagers upon teenagers, for your listeners. It is commonplace in Jamaica for two teenagers in their dalliances and upon their tryst to engage in these sort of sexual experiments. When they get caught, as is usually the case, the sad thing about it is the male, which is a boy, who faces the brunt of the court, who faces the harsh reality of the justice system, and who is exposed to the possibility of a conviction, imprisonment, and all the attendant factors that accompany that sort of thing. Almost always, the girl is seen as the innocent, non-participating agent coerced or forced into the situation.
One word for that is victim.
Victim. And from our experience as adult human beings, and from my personal experience and from the public and the personal experience, we can tell you that there are a lot of cases in which the so-called female victim is the instigator, the architect, and the driver of the conduct.
Oh.
But the way the law is framed, because it's so gender-specific,
The man feels the brunt of it.
thank you very much, sir, she really ever faces the brunt of the law. But you know, there's an argument that is made, sometimes I support it, that the sexual intercourse with person under 16 could be charged against a female because the wording of the act doesn't mention boy, girl, man, or woman, you know. It says personally. And there's a provision of the act which says he or she. But guess what? Because the conduct is a conduct of vaginal penetration by penis, it's going to be hard to charge a female for that offense in an actual scenario.
I'm listening to all of what is being said, and something crossed my mind. I don't know if it's something that we want to look at in another feature, but I want to put it out there. Can a husband rape a wife?
Oh, yes. In fact, that is provided for under the Sexual Offences Act, and it's called marital rape, and it does make provision for a wife to complain where in circumstances there is rape. And it says that a husband commits the offense of rape against his wife if he has sexual intercourse with his wife in any of the circumstances specified. In other words, without her consent, or knowing that she does not consent to sexual intercourse, or recklessly not caring whether she consents or not. It's the same principle.
Seven accept know that the wife is put under additional burden of proving one of the following things. She has to prove that they were separated and living apart, or there is in existence a separation agreement in writing between them, or that she has already filed for divorce, or he has actually filed for divorce, or there is an order of the court against him, non-cohabitation, non-molestation, or an order hosting from the matrimonial home, or that the husband knows that he's suffering from a sexually transmitted. This is an additional burden for the wife, which, well, I believe is a real vestige of the colonial past, where the days the wife was seen as the property of the husband. Because it's a strange rape, for want of a better word. All the wife, the victim would have proved vaginal penetration by the penis of the offender without her consent. In the case of marital rape, as the law terms it, that has to be proved of, and then the wife has to go further and prove on the additional factors that we have just mentioned to you. That's what we call marital rape. And if you were to canvass a view of people, you'll find that probably 99% of all women you speak to disagree with this notion of marital rape. They say rape is rape. And you know I agree with them.
Okay.
But before we part company, I just want to tell you about a brief respite that the male or the boy would have in sexual intercourse with a person under 16. The law is called the young man defense. Of course, a burden that he has to prove that he has to discharge. He has to prove that he's 23 years or younger, that before the one that brought him before the court, he has never been charged, not convicted, charged for this offense, and that he had a reasonable cause to believe that the girl is over 16 years. The first two I mentioned are easy proof. Those are things that can be ascertained easily. The third one is the one that he may get on a field task. But having said that, though, that is no guarantee that he's going to be acquitted, because that's a defense that the law offers him. A jury sitting on hearing could reject it out of hand completely and convict him. So while it's a possibly outlet from him, it's not an absolute get out of jail ticket.
Wow, we learned so much on this program. I want to use a scenario before you go. We're going a little bit over time, but I think it's important. There's a story that is currently in our space of a very popular MC who was doing an interview recently and made mention of an incident years ago when he got the consent apparently of a female, but there are two friends that he had who were not in a relationship and had no intimacy in their lives. And so he asked, and this was said on radio, by the way, he asked if the young lady would allow them to be a part of the act. Well, it turned out that some aggression was shown to her based on what he said, and she screamed out apparently, and everybody ran. And it's out there in the open. Is there anything like a statute of limitations that would preclude that female from many years later still putting a charge on this individual or these individuals?
Not that we know of at all. There's no statute of limitation that would prohibit her from lodging a complaint, making the appropriate identification and the requisite allegation of lacking in consent and the act that would prevent her from pressing charges and prosecuting that. In fact, up to, what should I say now, about 2 years ago, there was a situation where, albeit that this is incest, because it was a situation that existed between a father and a daughter. But she was alleging that her father raped her. And she got to the age, this was happening during her childhood, and she got to the age of about 58 or thereabout, and that is when she was bringing the charges or the allegations of rape against her father.
Well, maybe by that time.
And it was prosecuted.
Wow.
So I cite that example to demonstrate that no, there's no statute of limitation.
Wow, so this young man might have been implicating himself without even knowing it.
Oh, absolutely. Even but the other ingredients of the offense have to be established again, sir, because it can be shown that he reasonably believed that she was consenting. Then he may...
And had that also believing.
And just finally, to sort of wrap up on the last question that you asked of the public defender.
Yes.
Rape is what is called an indictable felony in Jamaica. Well, most all things are indictable. But the principle is that time does not run against the state in those offences. So it could be 100 years later. You can still press charge. The only issue might be, and that's a matter for the jury trying the case, the credibility of the victim. You know, people might say, so why you take so long?
Yes.
But I think we have said enough now. Time for us to close the window and call everybody for next week.
Yes, well, I thoroughly enjoyed today's program. I want to thank, of course, the public defender herself for springing this huge surprise on myself and my listeners. And thank you so much, public defender Carolyn Reed Cameron. I hope that you make this stop a few more times as we go forward.
You are quite welcome, and I must say that it's very interesting, the subject matter that has gotten you all this excitement bubbling up.
Yes, but people want to know. People need information, and that is why we're thankful that, constitutionally speaking, we'll definitely tell them about their rights under the Constitution. Thanks also to the Deputy Public Defender, Mr. Herbert McKenzie. We catch you again next week, and we wish you all a wonderful day today. Take care, and catch you again soon.
Thank you. All the best.
All the best. All right, that was Constitutionally Speaking, ladies and gentlemen. And I feel good. We gave a lot of information there. You can tell me if you have any comments. And by the way, I think you can also send me any questions that you might want for our guests to dissect on this program.
As a citizen, you have rights guaranteed under the Constitution. The Constitution is the supreme law of the land. Your rights under the law are yours. They are non-negotiable. You are legally entitled to exercise them and to have them protected from violation. Of course, with every right, there is a responsibility. Constitutionally Speaking is a program by the Office of the Public Defender. It empowers you with knowledge to protect yourself and your loved ones. Stay informed, stay empowered, be in the know. Catch Constitutionally Speaking every Tuesday at 8:05 a.m. on the Richie Morning Show, because knowledge is power.